So, welcome to the live webinar, finally. And thanks to Community Partnership on Aging and their plugged in programming new website or Facebook page, and for inviting me to come and talk to everybody here a little bit about advanced directives. So, advanced directives are really important. Everyone thinks they got to have a will. The idea with the will, however, is that it only comes into effect when you're dead. So it doesn't help you much while you're alive. Advanced directives are those documents that you need while you're alive so that somebody else can help you out. Somebody can help out with your financial affairs. Somebody can help out with your healthcare decisions. So it's real important to have advanced directives in place. And way too many people that I meet with say, well, I've got my will, right? That's all I need. And that's really not the case. So we're going to talk about 3 documents today that are critical mass. And they are the documents you need while you're alive, but maybe not able to take care of yourself anymore financially or for healthcare purposes. You got to have them in place. You also have to pick somebody that you trust implicitly to make your healthcare decisions, to deal with your financial affairs. So, think about who in your life is the one that you'd go to if anything happened that you'd want to be taking care of things for you. Probably a spouse, sometimes children, sometimes not. You know, you got to trust this person, and sometimes a family member may not be the right person. But you got to think about these things and have them in place before something happens. If you become incapacitated from a stroke or something else happens and you aren't able to sign these documents anymore, that's not good. If you don't have these documents in place before something happens to you, nobody has the authority to pay your bills, nobody has authority to talk to your doctors, and you might end up having to have a guardianship started. A guardianship is an action in probate court. It's kind of like probate when you die, but this is probate while you're still alive, and the court will deem you incompetent. It's public record, and then name somebody to take care of things for you, but it's all under the court watchful eye. What that means, though, is you have to go to court to ask permission to do anything, and it's just very much of a hassle. So you're much better off having these papers in place to begin with. So what are the 3 documents everybody should have? One is a financial durable power of attorney. Another is a healthcare durable power of attorney. And finally, a living will. So I'm going to talk about each of those in that order and tell you the main things you have to look out for, what they should include. And hopefully if anybody's got any questions and wants to give me a comment, I will try to answer those as we go as well. So first, financial power of attorney. So this is a document in which you appoint somebody, just as it sounds, to deal with your financial affairs. So paying bills, cashing checks, making deposits, opening accounts for you, closing accounts for you, accessing maybe your IRA if it's necessary to pay bills, all kinds of things financial. Typically, you want to name a primary person and then successors, because what happens if something happens to the person you first name and they're not able to do it anymore? You can't just name one person. That's one of the problems I see with a lot of people's financial powers of attorney is that they name their spouse but nobody else. Well, your spouse can get sick or die before you do, so you need to have successors. Also, people ask me a lot of times about joint financial power of attorney. I have 2 children. I want them to work together to make decisions and to help me. That's all well and good, but most banks don't like to have joint powers of attorney because they're afraid of what happens if little Johnny says yes and little Susie says no, and they don't want to have to make those kind of decisions or anything, so they don't like joint power of attorney. They especially don't like where either one can act just because you're trying to give them both authority and they don't even have to agree and either one can act. That's even worse. Banks don't want any liability for anything. They just want to be told what to do and do it. So joint powers of attorney for many banks is not an option. You might have to have more than one document so that either one can act, but it's only one at a time. And even banks now are asking for something called an indemnity clause in their financial powers of attorney. That's one of the things that we're updating documents mostly for, is because the banks don't want any liability if they don't, if they rely on a power of attorney. So little Johnny goes into the bank with your power of attorney and he says, Mom asked me to take out $200 for her, and I'm here as power of attorney to do that. And the bank gives him the $200. And it turns out Mom never asked him that at all. He just took it upon himself because he wanted $200. The bank's going to say, not our problem. He presented what looked like a perfect power of attorney. We did what he asked. We're not liable. You got to go after little Johnny. So the banks are very afraid of liability, and they want everything very clear in these documents. So don't appoint joint people. The power of attorney that you name can do almost anything that you could do with your money. It depends on how broadly you give that authority. You can give them the authority to do anything, everything with stocks, bonds, bank accounts, IRAs, to pay your bills, to make gifts of your assets. I mentioned that because that's really important for Medicaid eligibility purposes. And a lot of what I do as a certified elder law attorney is help people qualify for Medicaid, trying to protect assets. And one important thing to be able to do is have somebody be able to take those assets out of your name and put them into a trust, or put them into a spouse's name or two children's names, whatever is necessary to qualify for Medicaid. But that's a power that if little Johnny is allowed to take your money out of your name and put it into his name because the power of attorney says so, you better trust little Johnny that he's not going to just take it and run off to Tahiti. Money makes people go crazy. I tell my clients that all the time. So you have to trust 125% or more the person you're naming to have all these authorities, especially when there's gifting authorities and rights to set up certain types of irrevocable trusts that are necessary for Medicaid. You've got to trust that the people are going to do it the right way. Now, there is also two types of financial power of attorney. Durable means it lasts even if you're incapacitated. But there's a springing and there's an immediate power. The immediate power is easier to use because your power of attorney can pick up that paper and go do anything without having to get any kind of information from your doctors that you can't do it yourself anymore. So we mostly do immediate powers of attorney. But again, you got to trust your power of attorney because that document, they could take it and go deal with your banking today. Some clients want it to be only used by their named power of attorney if they are incapacitated or incompetent. That's a springing power of attorney. That language says, this is only effective if my power of attorney gets a letter from my doctor that says I'm not capable of handling my financial affairs anymore. The problem with that, it's more protective, but the problem with that is, have you ever tried to get a doctor to write a letter like that? Doctors don't like to say any of their patients are incompetent, and it can take weeks to get that letter. And if you need to pay a bill today, it's not going to be real helpful for you. So there's a lot of factors that go into naming a power of attorney. It's not really a simple document. It's a very important document everyone should have, but it's not all that simple. So for financial purposes, you got to have it. There is a statutory form out there that's written into the law that some people use, some attorneys even use. I don't particularly like that statutory form because some of these authorities, especially from a Medicaid point of view that I'm always looking at things for my clients, it doesn't include some of the bells and whistles that are necessary for using for a Medicaid planning purpose. So be careful. It's really not a do-it-yourself document because there's so many things that have to be dealt with and thought about. Okay, so financial power of attorney, money. Healthcare power of attorney. That's for making medical decisions. So there is a difference in when a healthcare power can be accessed and used by your power of attorney. The financial power of attorney, if it's immediate, they can use it. Even they can do all the same banking things and all the same financial things that you can do, they can do. But for a healthcare power of attorney, statutorily, it's a little different. For a healthcare power of attorney, it is only effective for your person that you've named to make your medical decisions if you are not capable of making them anymore. So the doctor asks you when he's talking about informed consent, do you want to have this surgery? This is what it's going to mean. These are the risks. These are the benefits. And you can't understand all of that and make a logical, reasoned decision, then somebody else who you've named in your healthcare power of attorney would be making those decisions for you. It allows that person to talk to your doctors, talk to the hospital, talk to your nurses. Just sort of, it gets past those HIPAA rules where they can't talk to anybody about anything. So the HIPAA rules are relaxed. Somebody else is named to make medical decisions. And listen to the doctors, get all that informed consent information and make the right choice. On a healthcare power of attorney, it is statutorily not allowed to have joint people named. Now, that doesn't mean your kids shouldn't all sit and talk about a medical decision that you might have to make. But it one at a time, that's who the doctors are looking to make the decision. The first named person, and if their dad are not available, then the second named person. So that is one person at a time just by statutory effect. That's what the law says. So your healthcare power of attorney is making these medical decisions for you. There's a companion document called a living will. And the living will works together with the healthcare power of attorney, but they have very different purposes or different ways of being used. If you have a living will, what you're saying in that living will is if two doctors agree that you are brain dead, right? There's no permanently unconscious, brain dead, or you're terminal, there's nothing anybody can do for you. You're going to die within a few days or a week, no matter what anybody does. In that living will, you're setting forth your wishes as to what should happen at that end of lifetime. If you can express it yourself because you're competent at that time and say, please, docs, don't hook me up to machines to keep my body going if there's no hope for me anyway, then they'll listen to you. But if you are no longer in a position to be able to make those decisions at end of life, then your living will stands for you to say, you putting in writing, I don't want to be hooked up to these machines under those circumstances. So the living will is only effective. It only does something if you are terminally ill, permanently unconscious, that's end of life. Two doctors agree, and you can't express your wishes at that point. You've done it in writing in the living will. The healthcare power of attorney, those are the folks you're naming somebody to make the decisions. So if you are at end of life, you can't express it anymore. You have a living will in place and the doctors say, okay, mom had a living will. She didn't want to be kept alive by machines. I think we're at this crossroads. A decision has to be made. So what is your decision? So the healthcare power of attorney is making that final decision using the living will as evidence of what that person, mom or dad, would have wanted. So it's really important. You need to have both because they work together for that end of lifetime. Now, that doesn't mean that if you're unconscious and can't make medical decisions, they're going to kill you. People get worried about that. Oh my gosh, I can't make my decisions. My power of attorney for healthcare is making these. And what if he says, let her go? I didn't like her anyway. It's not like that. The doctors don't take it lightly. And they're going to make sure that it's truly an end-of-life choice. Another thing about the living will, when your healthcare powers of attorney are thinking about decision-making and, oh my gosh, mom's really sick, what do we do here? You do not have to, under all circumstances, say, well, she wanted to die, so let her die. You have an option as the healthcare power of attorney to say, you know what? I'm not sure it's time yet. Why don't we give it another day or two? So you can override the terms of the living will to give a terminally ill patient a little extra time, and that's within the law that you can do that. However, you need to still honor that person's wishes. If they are to the point where there really isn't anything anybody's going to be able to do, and they really have to continue to be hooked up to these machines, and there's no brain activity, it doesn't mean that you can keep them alive indefinitely, but you can certainly say, give it a couple days, give it a week, and see what happens. Because sometimes people come back, but a lot of times, they don't. And if their wishes were not to be hooked up to a machine for the rest of their, many years of life, because a machine can keep your body going, then you should honor, whoever's the healthcare power of attorney should honor that. The healthcare power of attorney has these rights to make these end-of-life decision-making for the person who named them. They also have the right to make all medical decisions. So as I said earlier, what if you're unconscious? If you're not at end of life, the doctors aren't even going to broach the subject of living will. They're going to say, she's unconscious, we need to do an MRI, we need approval to process that MRI. So healthcare power of attorney is making very simple decisions through middle of the road stuff. Oh my gosh, emergency appendectomy. She's gonna have sepsis if we don't get this appendix out this minute, and she's not in a position to make that decision. Then they can make that decision. And then to end of life choices as well. So the healthcare power is very broad, allowing decision making across the whole range of decisions that need to be made, and the living will is specific to end of life choices. One thing that people don't understand, and I get questions all the time about, is, well, my husband had a heart attack at home. He fell to the floor. It was not breathing. There was no heart. I called the ambulance, and the ambulance came. And I told them, wait, he had cancer too. He doesn't want to be kept alive. Maybe this is a blessing, just let him go. The people who drive those ambulances are paramedics, but they're not physicians. The only person who can determine somebody is in an end of life time, where it's actually a living will choice, is if a physician makes that determination. And since the paramedics aren't physicians, they're going to resuscitate him as best they can, get him to the hospital, and then a physician has to make the determination about whether or not that person is at end of life, and therefore they can stop all of that. So I get clients who get very upset that their loved one was resuscitated when they didn't want to have been, and were taken to the hospital before that decision could be made. That's just the way it works. Paramedics can't make that decision. So I guess if your husband has a heart attack and is on the floor and has cancer and all these other things, and had talked for days about how they wish their life would just be done, don't call 911. Wait until it's clearly that person has passed away. There's nothing that they can do to bring them back anyway, and then call the police to send somebody and have them taken to the hospital for that final determination that they have passed away. And in the healthcare power of attorney, there is a provision that just in case, a guardian has to be named for you to make your medical decisions. If you have a healthcare power of attorney, a guardian for medical shouldn't be necessary, but there is the right that you can name somebody if you want the court overseeing what's going on, or there's problems between children and nobody can decide what should happen to you. There is a way that a guardian through probate court can be named. Once a guardian in probate court is named for an incompetent individual, then they're trying to make the best decision based upon what that person would have wanted. So if we have siblings arguing, mom wanted to die, mom wanted to stay alive, and there's an impasse there, it becomes a probate court guardianship with the court making that final decision. So there is that out there if issues are not good with the family. There's also the ability, if you're a financial power of attorney and for some reason There could be maybe somebody you named as a power of attorney is using the money inappropriately, stealing your money, doing financial abuse. What's likely to happen is that if you're not competent, somebody else in the family or adult protective services on their own accord, if they're notified that there's some abuse going on, would go to court and become guardian of the estate, which is the money. So guardian of the estate is like a healthcare power, but the court's watching over it. I'm sorry, like a financial power of attorney, but the court's watching over it. Guardian of the person is like the court watching over the health decisions. Now that's the last resort. Having these 3 documents in place should allow that nobody has to go to court and become a guardian, because you've set forth in writing what you want and who's supposed to be in charge of that. But it sometimes comes down to you need that court to make final decisions and to enforce them, to make sure that sister doesn't come in and try to get a new power of attorney signed that brother had, but brother's doing this and the sister wants to do something else. There is so much elder abuse going on in this country. Most of it is unreported. These are good documents to make sure that you've named somebody you trust to make those decisions and to carry out your wishes if you're not able to express them anymore. But there is also the possibility of them being used to abuse a person financially or even physically by refusing to make decisions under the healthcare power of attorney, refusing to put a parent in a nursing home or an assisted living when it's really necessary. So you're in those cases, a court might be better. So you're weighing how much do you trust the people you name? Do these documents say what you really want to have happen? And can you just rest easy knowing that your children or your nephews or whoever it is going to make a good decision for you? I've had a couple clients who said, I'm not signing any of those things because I don't know that I trust anybody that much with my money and my life. I'd rather have the court doing it, which is certainly a choice. Not very many people choose that because of the cost, complexity, and the fact that you're in probate while you're still alive. And court has to agree to everything, but it's out there as a possibility. I really recommend most people get these documents in place and just think a lot about who you name and what you want. And not only think about it yourself, but once you've named people, let them know, especially your healthcare powers of attorney, let them know what kind of treatments you want and what kind of treatments you don't want, so that they have an idea going into this and they're not just flying blind and go, oh, we never talked about it, I don't know what we should do, so that there's some guidance that you've given them even before they have to act on your behalf with regard to healthcare decisions. Maybe even talk to them about for financial things. I like these stocks and bonds, but don't put me in that if you have to take care of my finances. Giving guidance to the person who you've named to take care of things for you will really help them a lot. They will thank you for that. Plus, it makes sure that what you want is what actually happens in your lifetime when you're having to rely on those people to make those financial and make those healthcare decisions. So, get these documents if you don't have them. The financial power of attorney, I mentioned that there was a statutory form that most attorneys don't use. I would not use that for this. However, for the healthcare power and living will, that is a statutory form. That's the same forms we use for those. And they're widely available at hospitals and nursing homes and in the community and wherever you go online. You can get those forms as long as you follow the directions for how to fill those out. There's bunches of boxes that have to be initialed and lines crossed off, and it's kind of overkill what they do, but they want to make sure the person signing it really knew what they were doing. Healthcare power living will forms are out there. Make sure you have them. Financial power of attorney, see an attorney who does estate planning or elder law so that you can get the best possible document for you and your circumstances, and not the statutory form, which leaves out a lot of the bells and whistles that I look for in those powers. So with that, do we have any questions that anybody's got? Hi to people who said hello to me. If you have any questions, we got a minute or so for that. Otherwise, we're going to end it, and the video will be available. We're going to put it, well, it'll be on our website. We're going to put a link so that it can be on the community partnership, on the Plugged In Programming website. I think we even put it up on YouTube. So if you need more information, look at the video again. Call me. I'm happy to help everybody who calls, or at least call somebody. Just make sure you've got your documents all in order. Okay, seeing no questions, I will probably end this. And I thank you all very much for listening, and thank to Community Partnership for Carolyn Kriebel for inviting me to do this. And I hope you have a wonderful day, and stay healthy. This pandemic is making everybody crazy. Even more important these days to have these documents in place with the pandemic, and to talk to your family about whether you want a ventilator or not. So take care and have a good rest of the day.